lifting up new life and dormant life, and with summer inviting us to happier times. Some say that dusk is both the most beautiful and the most troublesome part of the day. That is why the subject of impending death in the dusk of our days is difficult. Today we are dealing with a bill commonly called physician-assisted suicide, or death with dignity, a bill that purports to address the decisions relating to end-of-life care, the dusk of our lives. The basic principles for and against this bill are these. One, that those in the shadows of life, as all of us shall be at some time, that they deserve the highest level of care, compassion, and caution from those in charge of society's resources, those in charge of its rules, laws, and mores. For those unable to care for themselves of whatever age, ability, or capacity, society has a paramount responsibility. It is society's role, both governmental and charitable, to lift people up, to give people the means to pursue the highest level of self-sufficiency, happiness, and opportunity. A law that permits the act of suicide by those nearing the end of life could be seen as an abdication of this responsibility. On the other hand, there are those who say that what government must provide, and all that it should provide, is the protection of personal liberty to the extent that the exercise of that liberty does not infringe on the rights and security of others. The opportunity for someone of sound mind facing imminent death to avoid further suffering is viewed by some purely as an act of personal liberty, a decision with which government should not interfere. In the context of LD 1313, the pursuit of individual liberty beseeches us to authorize in law an act of suicide with the assistance of the medical profession. Of course, an individual would be free, without punishment of law, to ingest a lethal amount of non-prescription drugs or to terminate one's life in some other manner, were it not for the requirement of the prescribing of a lethal dose of a drug. So the assistance of the medical profession presents a moral dilemma for many in the healthcare profession and for spiritual leaders who caution against suicide in any form and who caution against government placing its stamp of approval on actions that may devalue life, and who caution against the participation or assistance of government or of licensed professionals in life-taking measures. On the other side of the moral dilemma is the fact that medicine has found so many ways to prolong life way beyond the expectancies of the past. And what sometimes attends that extended life and extended disease is extended suffering, pain, great physical and mental discomfort. So what is the balancing of rights then when an individual in the throes of suffering and facing certain death, but while still competent, wishes to end life, denying death its ultimate pain? Some argue that LD 1313 equates to the government authorizing taking life or playing God with the lives of our citizens. But it's not up to government to determine and decide who may die, who may live, when they shall die, or how long they shall live. It is our duty to provide the most comprehensive end-of-life care possible, a task we have only recently begun to recognize. What is the responsibility of society when compassionate end-of-life care may not be adequate or accessible for all who need it? We have a duty, too, to prevent people from being victimized, to prevent discrimination against persons with disabilities, to make sure others do not take advantage of vulnerable citizens. Despite the narrowest of votes in the House of Representatives the other day, LD 1313 appears to be favored by a majority of Maine people surveyed, and it includes some, though not all, safeguards to protect the decision-making of competent, terminally ill patients, and to protect misuse and abuse of lethal medications and the diversion of dangerous drugs. This right to decide the means of ending one's own life by lethal prescription may be seen as an extension of the right to decline life-sustaining care that was articulated by a narrow 4-3 majority of the Maine Supreme Judicial Court more than 30 years ago in In re Gardner, 1987. The court found that the law recognizes a previously competent person's, a patient's, right of self-determination, in quotes, in matters of health care to be essential to the integrity and dignity of his person, end quote. In arriving at this conclusion, Chief Justice McCusick pointed to the classic articulation of individual autonomy by John Stuart Mill when he said, quote, "The only part of the conduct of any one for which he is amenable to society is that which concerns others. In the part which merely concerns himself, his independence is of right absolute. Over himself, over his own body and mind, the individual is sovereign," end quote. While I do not agree with John Stuart Mill that the right of the individual is so absolute, I do believe it is a right that should be protected in law, along with protections for those who are unable to articulate their informed choices and those who do not have access to quality end-of-life care. So after weighing these concerns then, and perhaps for these reasons and perhaps for others I cannot articulate at this time, I've decided to sign LD 1313. For all of these concerns as well, however, I'm also issuing Executive Order Number 9, which will require the Department of Health and Human Services to engage in emergency substantive rulemaking within the next few months. The broad purposes of this executive order are to provide a high level of protection for those in care and those who shall be in care, to track trends in the utilization of the law, to pursue our responsibility for end-of-life care as a society, to avoid the moral and social consequences of a law that in some way could facilitate the taking of life without the full authority of the individual. It is my hope that this law, while respecting the right of personal liberty, will be used sparingly, that we will respect the life of every citizen with the utmost concern for their spiritual and physical well-being, and that as a society we will be as vigorous in providing full comfort, hospice, and palliative care to all persons, no matter their status, location, or financial ability, as we are in respecting their right to make this ultimate decision over their own fate of their own free will. And Lindsay will give you copies of Executive Order Number 9, which I think is self-explanatory. Any questions concerning LD 1313?
In 1990, you were a district attorney, and there was a case involving a guy from Turner.
1987, that's the Gardner case.
I'm talking about the Chad Swan case.
Okay.
Regardless, in that case, you opposed a judge's decision that allowed the family of a young man to remove the feeding tube after a car accident. He was in a vegetative state.
That's the Gardner case. Yeah, go ahead.
And did you ever have a personal opposition to laws like this? Or, was that a microcosm of that, or was that your personal stance you were applying at the time? Have you evolved on it?
That was a different issue in a different time and a different fact situation. That individual was not competent to make a decision at that time. And the issue was not assisted suicide, really. The issue was life-sustaining hydration and nutrition, whether a court could order termination of that. And the issue as district attorney was enforcing the law that requires people to take care of endangered people, not endangering the welfare of incompetent individuals. That's really not in play in this, but they're not unrelated either. The legal ramifications. Yes?
Governor, is this the hardest decision you've had to make so far as governor?
Yes.
Can you lay out a very thoughtful legal case in your statement here? Can you talk us through the personal decision you had to make before making this decision to sign the bill? Did one trump the other, or is it a combination of both?
Well, I reviewed the testimony in front of the committee. I listened to some of the arguments, and I met with a number of people, and I reviewed incoming correspondence and emails. I talked with some people on the phone. I met with some people on both sides of the issue, basically, to understand where they're coming from.
The executive order, is that because you didn't feel like the bill had enough safeguards built into it to make sure there wasn't abuses? Can you just talk about?
Yeah, there are a couple of things. First, as I explained, the law will take effect 90 days after adjournment of the legislature. The law, now law, soon to be law, requires substantive rulemaking by the Department of Health and Human Services within 6 months after the effective date. Well, there's a gap there, and it's inconsistent. So I'm authorizing emergency substantive rulemaking with full consultation and comment period and consultation with entities involved and stakeholders concerning what kind of documentation should be reviewed, what kind of documentation should be required, what kind of informed consent should be required, and to allow the department over the short and long term to document any trends that might occur, any patterns that might occur as a result of the implementation of this law, and to monitor and safeguard our responsibility to provide palliative care to all those who need it, and hospice care to all those who require it.
And this may already be in the bill, forgive me for not knowing that. When someone makes the choice to end their life this way, will there need to be a report to the state of that happening or having happened?
The bill does require some documentation by the attending physician to be provided to the Department of Health and Human Services. I guess I want us to provide a little more holistic role in monitoring the progress of this law and implementation of this law to make sure that people aren't taking advantage of it as well.
In your difficult deliberations over this bill, was there any cause to reflect on anything in your own personal life experience that where this law been in effect? It may have been an option or may not have been an option. I'm just wondering how personal was the deliberation or not.
I have my own personal experiences, but more importantly, my decision was a result of weighing the pros and cons and experiences of many other people in the state of Maine and their desires and cautions and concerns.
All set?
Yes.
Thank you.
Thank you.
Thank you.
Thank you, everyone.